Okay, so we're going to start the meeting. Everybody who's signing in, when you finish, please take a seat. I'm Assemblymember Linda Rosenthal, and I'm so happy all of you could come out tonight. This is a rescheduled meeting because last week when we were going to do it, the street conditions were very dangerous, and we were afraid of people falling on the black ice. So we thought it'd be safer to cancel and hold it tonight, and I think it was a good decision because you are all still able to make it. You know, I've been in office almost 5 years now. In about a week it'll be 5 years. And many of the people who call my office have questions about co-op and condo-related concerns. And I have done a lot of tenant legislation. It's much harder in Albany to do any co-op and condo legislation for a variety of reasons. But I know many of my constituents have questions and concerns that they don't know where to go to get answers. So with the help of ACCO, which is a grassroots movement of condo owners and co-op shareholders, which helped organize tonight's event, we've assembled a distinguished panel of experts who are sitting up here, and they're each going to give a small talk about their area of expertise, or the area they were assigned to speak about today. And then if you haven't filled out a card or gotten a card, we're going to collect your questions on cards, and then I will read them from the front. Larry Sims, who's here to my right, is president of the Alliance of Condo and Co-op Owners, and I'm really grateful to him for putting this event together and building a great reputation hosting events like this across the city. I think this is your first West Side event, and so I'm proud to be hosting it with you. I'm also pleased to have Marissa Peisman from the Attorney General Eric Schneiderman's office, Kevin McConnell of Himmelstein, McConnell, Gribben, Donahue, and Joseph, and Bruce Cholst of Rosen, Livingston, and Cholst.
I'm going to talk to you tonight from the board's perspective about what the board's powers and rights and responsibilities and obligations to you as apartment owners are. However, before I go there, I've been asked to discuss the distinction between co-op and condo buildings, both from a legal perspective and from a practical perspective. So I'm going to start with co-op buildings. A cooperative association is a corporation, and the corporation owns the entire building. It owns each of the component apartments in the building, and it owns every square inch of the building's common areas. As with any corporation, when you buy into a co-op, you're buying a portion of its shares. If you're buying, for example, a 5% stake in a co-op association which has 100 shares, you're buying and receiving a certificate showing that you own 5 shares of the co-op corporation. And as in any co-op, at the time the offering plan is being drafted, the sponsor's real estate appraiser will assign a share value or share allocation to each apartment in the building. That share allocation reflects the appraiser's assessment of how desirable that particular apartment is relative to every other apartment in the building. Then that share allocation, that apartment is paired off with the share, a block of the corporation's stock equal in number to the number of shares in the appraiser's share allocation. And that's how the share value of each apartment is determined. And when you buy a co-op apartment, you are in effect buying the block of stock in the co-op corporation which has been paired off with the apartment that you want to live in. And as a result of buying that corporation, that apartment's block of stock, you are automatically entitled to the issuance of a long-term lease called a proprietary lease issued by the corporation, by the co-op corporation, to the apartment that you're actually looking to live in. So, in essence, it's a dual relationship that you have when you're a co-op shareholder. On the one hand, you're a shareholder of a corporation that owns the stock. On the other hand, you are a tenant of the co-op corporation, and they are your landlord. And that's going to be a very important distinction between condo ownership. I'll get to it in a second. But the co-op corporation is managed by its board of directors, which is elected by you as shareholders. And the board of directors acts on your behalf and makes management decisions on your behalf as your elected representatives. I'll come back to the governance issues in a minute too. But first let me get back to the share allocation. The share allocation determines two things in a co-op. First, it determines what portion of the building's operating expenses you are going to pay as maintenance, i.e. rent. And what happens is the board, in accordance with its powers, the board decides how much money is needed to operate the building on an annual basis. And in accordance with your share allocation, your apartment share allocation, you pay that proportional amount of the operating costs, whether by a regular monthly maintenance or by special assessment. Now, I mentioned a minute ago that the landlord-tenant aspect of your relationship as co-op owners to the co-op corporation, it's really crucial for several reasons. First of all, as with any landlord, the landlord exercises control over who comes into the building, who occupies the apartment. So whenever you are going to sell your apartment or sublease your apartment, you have to clear it through the landlord cooperative corporation as represented by the board. That's why the board exercises control over to whom you sell and why you appear before an admissions committee. Ditto, when you sublet your apartment, you have to get board approval because the board is your landlord and controls who occupies your apartment. Secondly, the co-op, as a landlord, has the power to evict in the event of your lease default, including your violation of the building's rules and policies which the board creates. That is at least in theory, it's a very heavy weapon to force you to comply with the rules and regulations, the threat of eviction. And that emanates from the landlord-tenant aspect of your relationship to the co-op. Thirdly, the co-op, as landlord, owns all common space in the building, and therefore it has absolute discretion on how that space gets used and whether or not to be able to sell it to shareholders, which is a very common phenomenon these days, shareholders buying common space when they combine apartments or buying a portion of the roof or buying outdoor space. So that really sums up your relationship as a co-op owner with the co-op corporation. A condo is completely different. A condominium is not a corporation. It's what's called an unincorporated association. The condo association does not own 1 square inch of the building's common space, nor does it own a single apartment in the building. All a condominium is a collection of homeowners residing under the same roof, sharing the operating expenses of the building and sharing the use of its facilities, and condominium owners are joined together in a very loose legal affiliation, which is framed by the association's governing documents, and I'll come back to the governing documents in a second. When you buy a condominium, you are not buying shares of stock, and you're not getting a lease because the building does not own the apartment, so it has no lease to give you and no stock to give you. What you're buying is real estate, as if you were buying a house. You're buying the land that's between the 4 walls of your apartment. You're also buying an ownership interest in common with every other unit owner in the condominium of the condominium's common space. And just as with a co-op, at the time of the offering plan, the sponsor's real estate appraiser assigns what's called a common interest allocation to your apartment, and that is your percentage of ownership in the condominium. It's your percentage of ownership in the common spaces. It also determines your proportion of the building's operating expenses as determined by the board when it does its budget. And it's also determining, both in co-ops and condos for the most part, with rare exception, it's determining your voting power in board elections and other issues that require voting by shareholders or unit owners. Now, the condominium is governed, as is a co-op, by the board. The board is elected by shareholders or unit owners. And, as I said, and when the board elects the shareholder, is elected by shareholders or unit owners, in effect, the shareholders or unit owners are delegating decision-making authority to the board for the duration of its term. So this is really an indirect democracy. As in government, you're electing the managers who are then empowered to make decisions on your behalf. This is not a direct democracy in which you get to participate in the day-to-day management decisions of your association unless you're also a board member. And that's important because so many people, when I encounter a dispute, so many people are miffed that they are not making the decisions, and yet they're bound by those decisions. It's really not a democracy, and common interest communal living, therefore, is not for everybody. A man's home is not his castle in a common interest realty situation. And the condominium and co-op governance is subject to the powers and limitations set forth in the building's governing documents. In a co-op, it's the proprietary lease and the certificate of incorporation. In a condominium, it's the bylaws and the condominium declaration. And the governing documents contain the board's powers and limitations on those powers.